Get ready for the dictation. Start. Testing the arguments advanced by learned counsel for respective parties on the testing anvil of service jurisprudence qua employer and employee relationship, I find that the admissibility of the pension of any employee would be dependent upon two factors: colon, within bracket first, pension as admissible to the class of service, semicolon, and within bracket second, the requisite period of qualifying service for such pension is attained, as per the rules stop. Both these factors are governed under rules framed stop. So far fixation of pension is concerned, it is dependent upon the salary last fixed and drawn as admissible under the relevant rules framed for such purposes stop. Any upgradation of pay scale admissible to a class of employee, if made after a cut-off date, such an upgradation cannot be made applicable admissible to employees who ceased to be employees of the establishment before the cut-off date, either by virtue of superannuation or resignation or termination removal, if such termination and removal has attained finality, unless and until such rules are given retrospective operation stop. So, unless and until such rules are held to be ultra vires and are struck down by giving it retrospective effect, an employee while in service will governed in the matter of payment of pay scale, and so also after retirement the procedure provided for computation of pension under such rules only stop. In the case of Exide Industries Limited versus Union of India and others 2015 second AD within bracket SC 635, the Supreme Court has very clearly observed that quote, in normal circumstances when an employee retires from service, his relationship with the employer comes to an end stop. It is also well settled that after retirement, normally no disciplinary action can, be initiated against the concerned employee stop. Similarly, the retired employee would not have any right of redetermination of his pension, but only in cases where salary is revised with retrospective effect, the retired employee gets the benefit of additional pension, and that too in certain cases stop decode. Para. Applying the above principle, I do not find that the applicant's case can be taken as an exception for determination of pension using upgraded pay scale by desired retrospective effect stop. In the entire judgment, non-compliance of which is complained of in this contempt application, I do not find any finding returned in favor of the petitioners applicants that even though they retired prior to the upgradation of pay scale of PPS HPS, they would be given benefit of the upgraded pay scale that was made applicable to such class of employees who were in service subsequent to the retirement of the petitioners applicants only because they retired as officiating deputy registrars stop. Thus, 3 employees who were wrongly given benefit of upgraded pay scale, necessary correction in their records have already been made stop. Besides that, there can be no claim of equality even if a similarly placed employee is given higher pay scale, which would not have been admissible in law stop. In the case of State of West Bengal and others versus West Bengal Government Pensioners Association and others AIR 2002 SC 538, the Supreme Court has cited with approval its earlier judgment in the case of KL Rathi, wide para 25, which is reproduced here under colon para. Again in KL Rathi versus Union of India and others, the case of the petitioner was that following Nakara case, he had to be given the same amount of pension as other employees of his rank irrespective of the date of retirement stop. The court noted that Nakara did not strike down the definition of emoluments and held that colon para. Quote, Nakara case does not lay down that the same amount of pension must be paid to all persons retiring from government service irrespective of the date of retirement stop. Even if pension is calculated on the basis of the same formula, the basis of calculation has to be the average of the last 10 months emoluments stop. This principle of adopting last 10 months emoluments as the basis for calculating of pension must be uniformly applied to all persons drawing pension from the central government stop. This was also laid down in Nakara case stop. It, however, did not lay down that the quantum of emoluments drawn during the last 10 months of service of each government employee must be taken to be the same for the purpose stop para. The emoluments have to be calculated according to the government rules in force at the time of retirement of the employee's stop.